In view of the issues that have arisen, one of the major issues that has arisen is the issue of limitation of time, which is a jurisdictional issue. So before this court can embark on dealing with any other issue for determination, it needs to determine whether the plaintiff's suit is statutorily time-barred. So the issue of jurisdiction, the issue of limitation of time as held in the case of Turanura Karauri versus Agnes Cheche goes to jurisdiction, and whenever it is raised, the court must deal with it before proceeding any further, so that if it finds that the suit was time-barred, then it downs its tool. So the plaintiff's case is that on 7th of April 2015 or thereabout, the second defendant, in breach of his constitutional mandate and statutory provision and the law, and without any reasonable cause or justification, maliciously caused the first plaintiff's name to be published in the Kenya Gazette on the list of persons suspected to be terrorist organizations. They seek judgment against the defendants for general damages, special damages, aggravated damages, exemplary and punitive damages, cost of the suit and interest, and an order directed that the first and second publish a suitably worded retraction. The first, second, and fourth defendant in their defense at paragraph 17 of their defense dated 5th September 2016 and filed on the same date have stated that any allegation amounting to the tort of defamation which is denied is statutorily barred and does not lie in law. The defendants in the plaint dated 17 are described as follows. The first defendant is the principal advisor to the government. The second defendant's office is established under an act of parliament. The third defendant is a public body whose functions are conferred under the act. And the fourth defendant is a public body established under an act of parliament. I have looked at the said description and I'm persuaded that all the defendants are public bodies as envisaged under the Public Authorities Limitation Act, Cap 39 of the laws of Kenya. Section 3 of the Public Authorities Limitations Act provides as follows. No proceedings founded on tort shall be brought against the government or a local authority after the end of 12 months from the date on which the cause of action accrued. 2. No proceedings founded on contract shall be brought against the government or a local authority after the end of 3 years from the date on which the cause of action accrued. 3. Where the defense to any proceedings is that the defendant was at the material time acting in the course of his employment by the government or local authority, and the proceedings were brought after the end of 12 months in the case of proceedings founded on a tort, or 3 years in the case of proceedings founded on contract. It is clear from the foregoing provisions of law that a suit based on tort of defamation should be brought within a period of 12 months. The Gazette notice which the injuries to the reputation of the first plaintiff arose was published on 7th of April 2015, while the suit to seek redress for the injuries suffered was filed on 13th July 2016, which is equivalent to 15 months after the said injury occurred. I have looked at the pleadings herein and noted that although the first, second, and fourth defendants raised the issue of limitation in their defense at paragraph 17, the same has not been responded to by the plaintiffs herein. PW3 on cross-examination by Mr. Wachira for the AG stated that the first plaintiff filed its case 13 months from the Gazette notice and later on filed a petition on 13th April 2015 to have its accounts frozen. No reason have been furnished to this court explaining why the plaintiff failed to institute its suit within 12 months. It is also noted that being a tort, the plaintiffs have been required to institute their claim against the defendants within 12 months from the time it was gazetted as an individual supporting terrorism via Gazette notice dated 7th April 2015. The plaintiff, knowing that its suit was statute barred, did not bother to seek leave of this court to file the suit out of time. I therefore find that the suit against the defendants is statute barred by dint of Section 3, subsection 1 of the Public Authorities Limitation Act. So going into the other issues would be an academic exercise. So that is the judgment of this court. So